Hi, and welcome to the next episode, episode number 9 actually, of the Elder Law 101 series that I've designed really to help my clients understand all of the issues that they may need to be addressing as seniors. My name is, for those of you who haven't seen the series, my name is Arthur Bergeron. I'm an elder law attorney. I'm at Myrick. We're the biggest law firm outside of Boston. We're a multi-specialty firm. There are about 80 of us, so everybody gets to do what they like. I like doing elder law. I'm 75 years old. I like it because my clients think I'm young. This series, which I did several years ago for the first time, is designed as a 12-part series, originally because I was doing these presentations monthly in senior centers, but I found that this structure worked well in terms of helping people really try to hone in on the issues that are relevant to them. I typically talk about my make-believe couple, Frank and Mary, and their kids, Peter, Paul, and Mary Jr., and I talk about them during these different ages. In episode 1, or in seminar 1, when they were under 60, where they have unique issues that are unique to that age bracket, typically focused on simply trying to avoid probate. Then I talk about issues to consider in your 60s when you're retiring, how you're dealing with your tax-deferred funds, etc. In your 70s, when you may be moving, you may be thinking about shrinking down, moving to a different location, trying to prepare for your issues as you get older. I then have a specific episode which originally was structured to be done in April at tax season, but it's income tax basics for seniors. There are some issues that are unique to seniors, which I talk about in that episode. I talk about life in your 80s, when people are really kind of worried about frailty and are often frail. I have an episode just dealing with how to qualify for Mass Health, which is probably the single greatest issue that folks talk to me about, how to deal with making sure that your assets don't get wiped out if you need nursing home care or need a lot of care at home, to avoid going to a nursing home. I have an episode specifically dealing with the last year of your life, and dealing with issues, things that you need to face during that time, whether they're because you're frail, because you know you may be dying soon, dealing with those issues. There was an episode on dealing with the things that you left behind, whether because those assets need to go through the probate process or otherwise. There's this episode, which is dealing with trust. One of the most common questions that I get, often the first question I get when people come in to talk to me for the first time is, don't I need a trust? And that's what I'm talking about today. I have an episode dealing specifically with the kids and the grandkids, how you're dealing with the issues that they may have after you die. I have an episode dealing specifically with Medicare, because everybody in our age group needs to deal with Medicare, or the options to, if you're not having, how you're dealing with your health care when you're old. Then finally, there's an episode on, which initially I focused on in December, because people at that time were focusing on giving, but also on tax planning. There are some issues that you really need to be dealing with then, and so that's what I deal with in that last episode. So today we're talking about my friends Frank and Mary and their kids, Peter, Paul, and Mary Jr. And initially I'm talking about them when they're younger, when they're say 60. And they've come to me and they've said, so, what, don't I need a trust? Everybody's got a trust. Well, first of all, you need to understand what a trust is. So a trust, as opposed to a corporation or a limited liability company, a trust is not a separate legal person. A trust describes a relationship between two kinds of people. The trustee, that is the person who legally owns the assets as far as the rest of the world is concerned. So that trustee would have the ability to sell the assets, for example, to sign a deed to property, to mortgage, to borrow money, to do a whole number of things. The point, though, is that the trustee in that case doesn't own the assets for himself or herself, although necessarily, but for the benefit of beneficiaries, other people who are beneficiaries, even though the trustee can be both a trustee of property and a beneficiary of property. So that's what a trust is. Why would you want a trust? Well, not because all of your neighbors have one, but because there is a problem that you're trying to solve. Trusts are meant to solve problems. The three problems that I bump into all the time are solved by three different trusts. If your goal is probate avoidance, that is, you want to structure things so that when you die, your assets don't have to go through the probate process, then you want to have a revocable and amendable trust, and we're going to talk about that. If your goal is asset protection, because you're concerned that if one of you dies, you want to make sure that your assets are safe in the event that the survivor needs to qualify for mass health, because they either need nursing home care or need a lot of care at home to avoid going to a nursing home. Then you want a testamentary trust. That is a trust that is part of your will. It will not avoid probate, but it will protect those assets for your surviving spouse. And finally, if you're a single person and you want to protect those assets, then you may want to be transferring those assets to a third party as a trustee of an irrevocable trust. That is a trust from which you cannot take things back out once you've put them in, as opposed to the revocable and amendable trust where you can keep control of the assets while you're alive. So, first, probate avoidance. Suppose you're Frank and Mary, you've got these kids, Peter, Paul, and Mary Jr., and your basic goal, you're still pretty young, you're not really worried about nursing home issues. You'd like to make sure, though, that if the two of you die, that assets will not have to go through the probate process before they get distributed to the kids. And say that these are Frank and Mary's assets. They've got a house worth about $500,000. Frank has an IRA worth $200,000. They've got joint savings of $200,000. Well, if Frank dies and Mary is still alive, there will be no probate in that case, because jointly held assets, like the house in this case and the bank account, legally are owned by by all joint owners 100%. So that if one person dies, that person's interest simply evaporates, leaving the sole joint owners as the sole owners of the property. So if Frank died, then Mary became the instant owner of all joint assets. Similarly, if Frank on his IRA had named Mary as the death beneficiary of those assets, the moment Frank died, the assets became Mary's, so there would be no probate. Mary died the next day, though, a probate would be necessary. And in the probate process is that Mary would need to go file the will, or if there were no will, file for intestacy, and get named as the personal representative of the estate, get a tax ID number for the estate, get all of the assets and put them into one big estate pile, sell the house if she wants to, but she'd need to get permission from the court to sell the house probably, and wait. She'd have to wait a year following Frank's death to see if any claims get filed against Frank, and at that point she could distribute the assets. All of those things would be true if Mary died and the kids needed to distribute all of those assets. At that point, the way the assets would get distributed would be, if there was a will, it would get distributed according to the will terms. If there was no will, the assets would get distributed according to the rules of intestacy. 1 year after Mary's death, all of Mary's creditors would have been wiped out so that the kids could now distribute these assets. But before they did that distribution, they may, if they want to be on the safe side, want to get an accounting of all of these assets and get it approved by the probate court. All of that takes time and money. To the extent that Frank and Mary want to avoid that in the event that they both die, and they want to simply get the assets distributed as quickly as possible to the kids, then the way they do that would be by creating a revocable and amendable trust. Revocable means whatever you put in, you can always take back out. Amendable, as the name suggests, is that you can change the terms of that trust at any time. You typically, Frank and Mary would typically become the joint trustees of that trust, but it would be specified that if one of them died, the other would become the sole trustee. So they'd have total control of all of these assets. They would also, if they were doing a kind of a broader estate plan, have a will, but the will would become a very simple will. It would only be there in case they had forgotten to put something into trust. And the will would simply say, it would simply say, if I die, any of the assets that I may have that had to go through this probate process, I'm simply going to pour into that trust, right? After the two of them have died, they would name one or more of the kids as the trustees of the trust. If they structured things that way, and the two of them had died, there would be no need for probate regarding any creditor asset, any trust assets. creditors would be wiped out. The assets could be distributed the next day. The house could be sold immediately without any need for probate. So there are incentives to be structuring things this way. In addition, because the trust is revocable and amendable, that is, any assets that are put in could always be taken back out. For tax purposes, the trust is a so-called grantor taxable trust. So that, for example, if Frank and Mary had taken their house and transferred the house to themselves as the trustee of this trust, and they turned around later and sold the house, for tax purposes, it would be as if they still owned it, which would mean they would still be able to get their capital gains exclusion of $250,000 apiece. They wouldn't need to be paying any capital gains on the house. If they die, the so-called tax basis of the house will still jump to the date of death value. So if the kids sell the house, they're not going to pay any taxes. If they're renting the house, or if they've got rental property that is in trust, they continue to be able to report the depreciation on their taxes. So for tax purposes, it's still theirs. Similarly, for mass health purposes, it's still theirs. So if either of them needs to qualify for mass health because they need nursing home care, need a lot of care in order to avoid going to a nursing home, as far as mass health is concerned, these assets are still going to be theirs and therefore may affect their ability to get qualified for mass health, which leads to the second reason why these folks may want to have a trust. That is, if they're older, say they're 70, they're getting nervous about this possibility of nursing home care, and they want to make sure the assets are safe if one of them needs nursing home care. So to understand how this asset protection mechanism would work, you first of all need to know a little bit about qualifying for mass health. And once again, there is a separate seminar that I've done, which you may want to watch if you've got a concern about this issue, that explains why it is that you can always qualify for mass health. But I talk about this a little bit in that seminar. So, if Frank and Mary are both alive, and say Mary needs to qualify for mass health because she's in a nursing home, she had a stroke, she's going to be in a nursing home for the rest of her life, and say these are their assets. Say they've got a house worth $500,000, Frank has a IRA worth $200,000, they've got savings of $200,000, so they've got quite a bit in assets, right? Mary can still qualify for mass health immediately if she's in that nursing home and Frank is still alive. The reason for that is, while Mary would have to show that she had less than $2,000 in countable assets, Frank could own the home. Frank could have other cash or cash equivalent assets as long as they're of no more than $157,000. But he could also have unlimited income. Therefore, what I would advise Frank to do in that case, if Mary needed to qualify for mass health right away, would be right then to transfer all assets to himself, which he could do even though Mary didn't have the ability to sign anything, as long as Mary had given him a power of attorney, naming him as her agent and saying that he had the ability on her behalf to transfer assets to himself. What I would say to him, Frank, is transfer all assets to yourself, and there is no look-back period regarding any of these transfers because it's a transfer to a spouse. Then, that your house is immediately safe. Because you've got too much in money, though, because he would have over $157,000, what I would tell Frank is go buy an annuity, which has some specific terms. It needs to be irrevocable, and it needs to call for equal monthly payments over a term that is shorter than Frank's actuarial life expectancy. As long as he does that, thereby reducing his remaining assets to below $157,000. The day after he buys the annuity, Mary can qualify for mass health. From then on in, her income from pension and Social Security will go to the nursing home. Mass health will pay all the rest. The other thing that I would tell Frank to do, though, and I often tell folks that they can do this, you can do this, Frank could do this at the last minute after he had gotten Mary qualified for mass health, right? But he may want to do it ahead of time, he may want to have a will that says, instead of the will saying, when I die, everything is going to go to Mary, instead, he would want a will that says, if I die and Mary is alive, that these assets that I own are going to go into this testamentary trust. Testamentary means a trust that is part of the will. Does not kick in ahead of time. No assets get transferred into trust ahead of time. It kicks in the moment that Frank dies. Through his will, he says, any of the assets that I leave at the time of my death, I want to flow into this testamentary trust for Mary's benefit. You would typically name one or more of the kids, Peter, Paul, and Mary Jr., as the trustees for Mary's benefit. And the trust would say that following Mary's death, any remaining assets would go to the kids. So the trust is part of the will. It only takes effect at death. You can name one or more of the kids as the trustees. All the assets that are in that trust that were owned by Frank and therefore flowed through the will into trust for Mary's benefit are immediately safe, non-countable, and non-lienable following Frank's death. They can be used in any way that the trustees deem appropriate for Mary's benefit, but they don't have to be used to pay for Mary's nursing home care, and there's not going to be any lien on them that Mass Health is going to impose as a result of qualifying for Mary for Mary's following Mary's death. So, oftentimes I recommend to people, even if both of you are healthy, what you may want to do right now if you're married is have these wills in place. So each of you saying, when I die, any assets that I own are going to go in trust for my spouse's benefit if my spouse is still alive. Knowing that as time goes on, if one of the spouses gets sick, you now know which spouse is sick and why, and therefore can do these asset transfers. For example, suppose Frank and Mary came to me if they had those wills in place, and Frank said, I found out I got cancer. I'm not going to die tomorrow. Cancer doesn't kill you in a day, but I may die soon. I want to make sure that my spouse is safe. At that point, what I would tell Frank and Mary is, if you want to be on the safe side, you may want to transfer into Frank's name individually the house and any other assets that you want to make sure are going to be safe, non-countable, and non-lienable in the event that Mary later needs to qualify for Mass Health. If, on the other hand, Frank told me, I'm having some memory problems, not now, but later I may need nursing home care, I would tell Frank, you don't have to do this now. You don't have to transfer any assets right now, because as long as Mary is alive, if you later need nursing home care, at that point, you can transfer them to Mary. Mary can buy the annuity, take all these other steps that I already explained. But I would say to Frank, if you want to be on the safe side, to make sure that you're protected in the event that Mary suddenly dies, that you may want to transfer the assets to her now, like the house or the cash, so that these assets will be safe, non-countable, and non-lienable in the event that she dies and you later need to qualify for Mass Health. The other implications of all of this planning, though, the trust that I'm talking about, as I mentioned, is a testamentary trust, a trust that is part of the will. Therefore, in order for it to take effect, the assets have to be owned by Frank at the time of his death. They have to go through the probate process. And at the end of that probate process, then get transferred into the name of whoever, the kids typically, as trustees for Mary's benefit. After the probate distribution, the trust is going to get its own tax ID number. Once again, one of the benefits of all of this is that if Frank owns the house, even if the house was transferred to him at the last minute, at the moment of his death, the so-called tax basis of this house jumps to the date of death value. So that if Frank owns the house, Frank dies, and Mary is already in the nursing home or wants to sell the house or whatever, the tax basis has jumped to the date of death value. If the trust needs to sell the house, they aren't going to pay any capital gains tax. Finally, what if Frank and Mary hadn't done any of this? They had simply left their assets in joint names. One of them, Frank died, Mary became the owner of the assets, and at that point she came to me, and this often happens, typically with one of the kids, and says, Frank's dead, I'm getting older now, I'm worried about these nursing home issues, I want to protect these assets. In that case, what I would tell Mary is, the only way you can protect those assets is to transfer them out of your name and wait 5 years. If you've only got one child, what I would typically say to Mary is, just transfer all the assets to that one child, as long as you trust that child, and you trust that if you need any of these assets, that child is going to use the assets for your benefit or give them back to you. If you've got multiple children, then, which is the case in Mary's case, what I would typically recommend is that you create this irrevocable trust. So say Mary has these assets: the house, $500,000, Mary's IRA, because remember, Mary would have inherited Frank's IRA, so she's got the $200,000 in the IRA, and savings worth $200,000. What Mary could do, if she needed to qualify for Mass Health, she would have to spend down her money to less than $2,000, spend down, that is, the cash and the IRA money. At that point, she could qualify for Mass Health, but Mass Health would put a lien on her home for repayment. If she didn't want that to happen, what she could do is she could transfer whatever, she could keep in her own name whatever amount of money she just wanted to keep in order to know that she'd be able to sleep at night. She would transfer the remaining assets to an irrevocable trust. Irrevocable means whatever she puts in, she can't take back out. She would name, and regarding the house, what she would do is she would transfer to the irrevocable trust a so-called remainder interest in the house. That is, the interest that starts after she dies. She would keep a life estate in the house. That is, control of the house until, for as long as she's alive. 5 years and a day after she had done that, all of the assets that she transferred into trust would be safe, non-countable, and non-lienable. Regarding the house, the remainder interest that she had transferred would be safe, non-countable, and non-lienable. If she then needed to qualify for Mass Health, she could. Mass Health would put a lien on her life estate so that if the house were sold during her lifetime, Mass Health would be entitled to a piece of the proceeds equal to the value of the life estate. But as long as she kept the house until she died, and this is what I would tell the kids to do, as long as she kept the house until she died, at the moment of her death, that lien would expire, leaving her kids able to sell the house lien-free. Now, typically, the trustees of this trust cannot be Mary, right? What she puts in, she cannot take back out. She cannot be the trustee, but she can have the kids as the trustees. She can't have the power to order the kids to give her any money. We would typically name the beneficiaries of the trustee, or the beneficiaries would be the children. And the children, as the trustees, would keep the power during Mary's lifetime, if Mary needed something, to transfer money to themselves and then turn around and use that money on Mary's behalf or give the money to Mary. And regarding the house, they would simply continue to have the house, keep the house in trust. They could use the trust funds to pay for the taxes and the insurance, etc. Once again, they could always make distributions to themselves, and they could make gifts of those funds to Mary. The additional benefit of all of this is that at the moment of her death, whatever assets are remaining in this trust would be, once again, safe, non-countable, and non-lienable, and could be distributed to the kids immediately without without having to go through the probate process. For tax purposes, you can structure this so that it is also a grantor taxable trust, so that even although these assets are in trust and earning interest, the tax on that interest would still be taxed to Mary at Mary's rate, which would be much lower than the trust rate. To the extent that Mary needed more money, remember, the trustees would always have the discretion to distribute money to themselves and then turn around and give that money back to Mary. And once again, one of the other advantages of this would be you'd be eliminating probate following Mary's death. So, in summary, trusts are meant to solve problems. The three most common trusts that I deal with are the three that you just saw. If their goal is probate avoidance, you want a revocable and amendable trust. If your goal is, if you're two spouses and you want asset protection, the goal is a will with a testamentary trust. If you're single and you want the assets to be protected, the goal is to transfer assets to an irrevocable trust. I hope you found all of this helpful. If you've got any questions, you can see this presentation again, or any of my presentations on my YouTube channel, Elder Law Frank and Mary, or you can always email me or call me, and I'd be happy to talk to you about any of these issues. I hope this presentation has been beneficial. Thank you very much.